Hello ji, good afternoon, everybody, and all those fasting. Assalamu alaikum to you as well, and we hope your fasting is going very well. Today we have another Facebook live session on immigration and some property matters, and today joining me is our partner here of the firm, Nazir Ahmed Naji, experienced solicitors, and he will be discussing the equity issues in property matters. So we will discuss that as well. But as usual, we will start with basic changes in the last few days in relation to immigration. And then whatever questions you have, you can ask us here. And like always, you can send us an email as well on info@m-rsolicitors.co.uk, or you can ask questions here. So the basic minor changes we had in the past few days. I start with the startup and innovator visa. As we discussed previously, that in startup and innovator visas, the main key factor of these visas are the business plans. So if you have your business plan, that business plan must be endorsed by the endorsed bodies in the UK, which include quite a few of universities, about 120 universities and about 24 other bodies who can endorse your business plan. Universities, most of the universities, they prefer their own students for those who have graduated from same universities. They do not treat or accept the business plans from other people, but some universities do. And then there are other bodies who can take your business plan and can endorse if they are satisfied. So the change here is in the business plan is that you must be the founder of that business plan, and the business you are doing, you must be the founder of that business. And if you are coming to join a business, or the business is already trading, again, whether in partnership or not, again, the business plan, the business, you must be the founder of that particular business and business plan. If you are not, you are just joining in existing business, they will not accept and they will not give you the endorsement on that. So the business plan must come from the founder. The other change is which was not as per se, but now the situation is that they have announced that even if the endorsed body has given you the endorsement, the previous presumption was that once you have got the endorsement, you will get the visa. But now what the Home Office has suggested that no, even if they have endorsed, the Home Office has the power to review it and to see whether the endorsed body has covered all the checks and they have fulfilled the criteria, they have met the criteria. So the endorsement procedure was met or not. So they are having the final say, even though your business plan has been endorsed by the body. So I think this is the way they can control the number of people who will be applying. So another explanation they have made, clarification, is in terms of viability. You see, the business plan has to be genuine, has to be viable and scalable. So in terms of viability, they have clarified, even though those people who were making this business plan, at least we were advising them on this already, but probably Home Office thought that it should be better if they make it more clear. So they say the business plan must be realistic and it must be achievable based on your available resources. So whatever business plan you are bringing up, you must show that it is viable, number one, because it is a realistic. It's not a dream which cannot be fulfilled or which will never become true. And it has to be achievable with the resources you are putting in. So in the business plan, you will be showing your financial resources or your educational resources, your experience, all that comes in resources as well. So you have those to back up the business plan. So it will be considered as viable. Otherwise, it won't be considered as viable. The other good change is that if you have made a business plan, you got the endorsement, you got the visa, and you have started your business, you have come to the UK if you are coming from abroad, and later on you realize that this is not the business for you and you got a better idea and you want to change the business venture. So the previous situation was that you make a new application to the endorsed body. If they approve, then you go back to Home Office. and you get a new visa on those basis, but that is not the case anymore. So as long as the business plan is again just endorsed by the endorsed body, so you are rather notifying them the change of business, and the business plan has to be still endorsed by them, and that's about it. So you can in between change your business venture. This will help especially those who are coming up from startup visa to innovator visa, so they don't have to go through the 50,000 endorsement because their business is progressing, and if they want to change the venture, even they can do so. So if you have particular question on that, if as per your circumstances, please send us an email on info@m-rsolicitors.co.uk, and we will be in a position to explain you better. The other changes, there are few higher education providers who were allowed to endorse the business plans for startups. They have been given permission to endorse even innovator visa business plans as well. And also they have announced any government department, this was not the case before, any government department in the UK can become endorsed body. These are the main changes. There's another change that in relation to EU settlement scheme, that when you are making an application on the basis of your sponsor that you have lived here, and your sponsor, they need to mention the continuous qualifying period. So the previous understanding was that when you're making an application, still your sponsor has to be in that continuous qualifying period, even though he has been for long. But now if he's not, then your application may be refused, but that is not the case anymore. So as long as you have established 5 years and then there is a gap, and at the moment he is not into that continuous qualifying period, still you can make the application. So this is a positive change. Again, European Union settlement scheme, if you're making an application nowadays with the form, you can just send the form via email, which was not the case before, and the email will be written on the application form which you will obtain. So you don't have to do it by post, you can just email them. So these are the changes. There were other changes as well, which are in relation to sole representative of an overseas business, but rather they are a bit more clarifications rather than changes. So if you have again any specific question on that, you can send us the question and we will try to respond to that. Again, welcome to all those who are there who have joined us in this session. So if you have any questions, please let the questions come in. And again, I come to our colleague Nazir Ahmed Naji Sahab. He's expert in immigration as well as property matters. So we thought, why not we elaborate a little more on a different issue in property matters. So I bring in Nazir Ahmed Naji. Welcome. And I'm sure we will have some useful information from you, the research you have done, and let's see how it can help our viewers.
Thank you very much. First of all, Assalamu alaikum. Welcome to everyone. Hopefully you will be enjoying your Ramadan. Whatever days are left, I'm sure you all will be praying a lot and making the most of the time. Basically, I wanted to discuss about property matters. Although we deal with a lot of property matters, especially buying and selling and other lease matters, but I wanted to particularly discuss about equity matters in property law. As you may be aware, there are 3 forms of law in England and Wales. Mainly law comes from legislation through acts of parliaments, and then there is a law which is made in the courts by way of case law, whereby superior courts, superior judges, they pass their judgments, they become the part of the law. Then that is commonly known as common law. But since 11th century in the UK, the courts have developed equity principles. Basically, initially there was no equity available in law, but then people had claims, they couldn't fall under law, so they couldn't claim anything. They used to then go to the king and file their claims over there. Over the period of time, then things developed. So over a period of time, the courts started to create their own precedents, and they build up this law which is called now equity law. So equity, basically, there are different definitions. Mainly you can describe it as something being fair, something which is moral, or something which you believe it should have been done. So wherever there is any weakness, or you can say you feel unfairness, you can then go to courts, and under equity you can present your claim. For instance, you have exchanged, you have completed with the other party, and now somehow the other party is not willing to, or there are change of circumstances. So in equity, even if that party says no, or their circumstances change, they can't go any forward, you can in equity go to the court, make an application for specific performance, and ask the court to bind the other party to do the specific thing which they meant to do. So clearly you can see that the equity then comes to your help in a lot of different situations. For example, if we talk about tort, if we talk about contract law, for instance, you have an insurance policy. Somehow you are paying all the installments, somehow your installments stop, and you are then, one of your partner dies, and then you start to make a claim. There was a case law which I am referring to. So the partner died, but the insurance company stopped making their payments. They didn't honor their claim, but then the parties went to the court. In the court decided the case under the law of equity. What the judges said, look, if this person didn't receive your letter which you were supposed to, which they were supposed to receive, and then they were going to make their contributions, so whatever their contributions are missing, deduct that payment from their claim and then pay their claim.
Right.
So basically, the court looked at the things that, okay, they missed the payments, but what ought to have been done? So clearly, in situations like these and in other similar matters, for instance, you are living with a partner in an unmarried relationship, or even in marriage, but somehow your marriage is not registered, and then you are a housewife, or you are making contributions towards your house. So over a period of time, you have made these contributions by way of money, by way of spending your time. So all these things accumulate over a period of time. Even if your name is not on the title deeds, if you have been making these contributions by way of spending your time, or making your contributions, or using any other method, then you have a proper claim under trust law and under equity, that you can claim your share from the property, even if your name is not on the title deeds. So that's where I think people should be concentrating. If anyone, for example, has any issues like these, they can come to us, and we can then make their claims under equity, and we can help them. For instance, recently we received there is a case in pipeline whereby some person was living as a tenant somewhere, but somehow the landowner of the property went missing. And this guy, instead of being a tenant, he acted just as an owner. He was making contributions for these 14-15 years. So now clearly, although his name is not there on the title deeds, he still has a claim. But to prove his claim, he has to go through this equity and then file a case, file a claim. Will decide, look, this person has contributed and he was clean, his hands were clean, he was making contributions, he should be able to get the fair share of contributions which he has made.
Very interesting, Naisab. When I was doing my law, equity and trust used to be a very dry subject, and I didn't have much interest in it. But since we have been practicing, I've been practicing like for 21, 2 years now, and we say that it's not that dry as it was in textbooks. It's very interesting. So if you have any equity matter that you have been staying in the property for a long time and you have been contributing, it is like husband and wife, even one partner, one spouse has bought the property, the other has been contributing towards the upkeep of the house. There are very, very clear decisions that even if the wife did not work and she was just contributing towards the upkeep of the house, maintenance of the house, then she should get the share of the house as well. So there is a very clear law now on equity. So if you have any questions arising out of this discussion today in your mind, please write to us on info@m-rsolicitors.co.uk, and I am very much delighted that some of my colleagues are watching this Facebook session as well. So please do give us your feedback as well. There are a few questions. We will just try to answer those as well. Welcome to Junaid. Thank you, Junaid. You have asked a couple of okay, mobility scheme for Pakistan. Unfortunately, this youth mobility scheme is not for Pakistan. I did discuss in one of the previous sessions, they are for different countries, but Pakistan or India or Bangladesh or Sri Lanka, these countries are not part of that scheme. But if you have any specific question, then I'll let you know. You can email me. So unfortunately, it is not for Pakistan. Another question, Mohsin asked, what about the overstay and reporting week by week solution? At the moment, obviously the reporting centers are not working until to date, and this will be the situation at least until the 31st. So you don't have to go for reporting. Even after that, if they do ask you to come and you're not feeling well because of the situation, because of the transportation, you cannot go, you can't afford to go, you can write to them and your request will be considered. So many people have been asking, Naisab, in the previous sessions, as well as we are getting questions here and via emails, that considering the situation, all those people who have been staying here without documents, they are hoping, and as lawyers we have been hoping for a long time, that the government should be considering some kind of announcement, at least at the time when Brexit is going to happen and we will still need people to work here in this country. So if on one hand, it's a big if though, but if on one hand you're considering people to bring from outside the country on work permit or whatever policies or categories, point-based system, which has been announced yesterday or day before as well. So rather doing that, first of all, around 1 million people who have already been in this country without documents, and there's so many skilled people. There's so many people who are qualified teachers, nurses, even doctors, but they cannot work because they don't have permission to work, they don't have documentation. So don't you think this is the time when the government should consider this?
I think Boris Johnson has been on record for a number of times. He has promised, and he has said this, that he's behind this amnesty, and he has publicly said that few times he has said that. I think it's a good time for him to honor his commitment, which he has made on a number of occasions, and especially in the current climate, it will make more sense.
Yes.
It will make more sense. For example, today the government, UK government, launched a scheme whereby they are recruiting an army of people just to collect this food
Yes.
food crops.
Yes.
So they're asking people to help them.
Yes.
So if they offer this help to those people who are illegal here, especially a lot of people from Asia and other countries, they can be helpful, and they
Yes.
can, yeah.
But you see, the Home Secretary on record again that kind of disowned that statement of Boris Johnson. So there are so many organizations who deal with refugees, who deal with immigration people. They have been writing to the Home Secretary and the government that this is the time you should be considering. So if you have contact with your MPs, please do contact your MPs. Try to make some sense to them. Look, this is the situation and this is the right time to make this decision. So they can push the cabinet and the government, whether your MP is from Labour Party or from the government party or any other party. It makes sense that go to them, speak to them, and if you can organize some committees and do something collectively, then definitely it will make a difference. We have questions. There is a question from Asad. Welcome, Asad. If someone don't have any property in the UK, can he buy his first property under company's name? Definitely. Company, I understand company means a limited company. So limited company can own an asset in the country. Whether the company will get a mortgage or not, it is a question to be asked from the bank, but there is no restriction on lenders that they cannot lend the money to limited companies. There are so many businesses, so many properties, whether it is residential or not, owned by limited companies. And since some changes in the taxation for past few years, so many people who personally own the residential portfolio, they have been transferring that portfolio to limited companies because it is more tax efficient. So yes, number one, you can buy property on your limited company's name, whether it is first time. Secondly, yes, lenders will be willing to lend if the company fulfills the criteria. So I hope I answered your question. But
I would like to add
please.
a little bit on that. We have clients, especially who has formed companies, SPVs, special purpose vehicles, only for this purpose. So the companies, they only own assets in the UK. So this is a clear practice since number of years. So you can clearly do that. That's not a problem.
Okay, it's a general question. Someone asked me, welcome Aisha, that how much time Home Office is taking to make decisions on FLR, FP applications. See, before this pandemic situation, the Home Office target was to make a decision on any of these kind of applications, if it's a standard application, maximum within 6 months, but practically speaking, the Home Office was making decisions within 8 to 12 weeks, within about 3 months. But since this situation, even if you have made the application and you have not been given the date for biometrics, because all the biometric centers are closed until today, and this may remain the situation until 31st of May at least. There was another question from another viewer, and they were asking about when the BRP centers will be open. So biometric centers are not going to open for another 2 weeks or so at least, and we still waiting for further information from the Home Office that when they will start accepting issuing the appointments for biometrics. So at the moment we are not in a position to give you any timeline how much time FLR FP application will take if you're making it now. You can make an application online, and I have been stressing on this, that if your visa is expiring, please don't wait, just make an online application, and whenever the centers are open you will get the biometric date. Even though if you cannot do the English language test, if it is required because of pandemic situation, you cannot take the test, still make an application. If because of pandemic situation you have been furloughed, or you have been asked to leave the work and you don't have any work and you cannot meet the income threshold if you are on spouse visa and your visa is running out, still make the application with a covering letter that because of this situation I am short of 2 or 3 months salary, and because of that I cannot meet the minimum threshold. Make the application. This is a wrong information, wrong perception that the Home Office is considering to lower the threshold. They have categorically stated that on their website that they have not considered this, but all the cases which will come to them, they will see case to case and they will decide. So in these circumstances, what they will do is either they will hold the application, and once you start working again, and they will you can send them the information. But if that is not the case, then they will still grant you a temporary visa, an extension kind of thing, and once you're ready, you can submit the application again, and they are not going to charge you double fee. They are not going to charge you again for the same visa. So these guidelines are very clear, so please do not overstay, just make application. Again, I stress, until 31st of May, all the visitors who have come to this country and their intention was to go back and make some sort of long residency application, whether it was settlement application on behalf of children as parents, whether it was for innovator visa, startup visa, student visa, spouse visa, all these applications, work permit tier 2 applications, all these applications, you still have time until 31st of May that you can apply for switching, which was not allowed. It is only on discretionary basis they have allowed, so you can still going back and coming back, and saving time. So this is still an information which not many people know about. Naisab, have you come across any kind of this case?
Yeah, I just wanted to add a couple of points on this. Firstly, if there is any deficiency in your application, there is a Home Office rule which has been in place for decades now, that Home Office has a discretion.
Yes.
They have discretionary powers, and they can exercise that discretion in your favor. That's one thing. Secondly, there is a Home Office policy in place whereby they have undertaken, the Home Secretary has undertook that there will be no adverse effect on the applications because of coronavirus.
Right.
So for instance, if anybody's application does not meet the threshold, although the Home Office has not made it absolutely clear, but from this statement, from this undertaking, me as a lawyer, I would say they have already clearly undertaken that there will be no adverse effect on the applications because of coronavirus. So if somebody's application is lacking, if there is any deficiency, say for instance they can't meet the threshold, I would advise them to make applications under the discretionary powers, and they can also mention this Home Office policy which is in place, and they can rely on that, and hopefully they'll get a positive decision.
Thank you, Naisab. So Naisab has made it more clear. Further, if you have any specific question in relation to your case, as I say that, send us information on info@m-rsolicitors.co.uk, and we will be in a better position to respond to your particular query. Welcome, Bilal. Your question is that one of your friend has withdrawn his appeal from the court and now submitted fresh application within 14 days on the basis of tenure category for ILR. So he still can go for it. Yes. If your appeal, and before that there was no gap, and appeal was validly lodged in time, and before the decision came you withdrew, at the same time you have made the fresh application, there is no gap, so yes, your residency will be continuing, and there shouldn't be any problem in your 10 years application for indefinite leave to remain if all the other requirements are met. So we don't see any problem on that. There's another question from Tessie. Tessie, welcome. People are here for 10 to 15 years and yes, any information that, as we said, the government has not announced any policy for those who have been in this country for some time without documents, but there are two categories which I want to elaborate. One is, everybody knows, or most of you know, that if you have been staying in the country for 20 years, you can make an application and you will get again 2.5 years visa under the 10-year category route, because directly indefinite has been kind of finished from 2012. So now you get 5 years visas, you get 10 years visas, and then you get indefinite leave to remain. So And there's another category, though, for those people who have been in the country for less than 20 years. It's not that you cannot make an application. There is a rule under which you can make an application if you have been in the country for less than 20 years. However, you have to establish that your family life, your cultural life, your economic circumstances, everything has been disconnected from your country of origin, and you have established all that in the UK. And the more evidence you can attach to it, the better chances are you will get visa. We have quite a few cases where people have spent over 15 years, less than 20 years, and they have been granted status by the Home Office. So it will vary case to case. So your particular case, you better speak to the legal representative face to face, and he or she will be in a better position to explain you that what sort of documentation you should be considering to submit. So for example, if you have been working, so they will consider whether you have been working legally or illegally. It also matters what sort of skills and education you have. In some cases, people come up with ideas that, look, I have this skill, I have this extraordinary business plan, I have resources. If I'm given a chance to work here, if I'm given status in this country, I'll establish my own business in this particular field, and I will be in a position to employ UK residents. So rather than becoming burden or looking for work, he or she will be in a position to employ other people. So we in the past have tried, especially for ladies in these beauty parlors, we have tried in IT sector. These are the areas where their IT sector, still it is in shortage of occupation. If you to do with anything to do with electrical engineering, electronics, these ideas, it comes on in shortage occupation list. So you need to see what area or field or occupation is in that list, and if you come into that and you make a better, good business plan, I think it is very, very likely that the Home Office will consider your application positively. Otherwise, if you just say I'm here for like 15-16 years but there is no documents, there are so many people who have been in this country even for 20 years, but when we ask them, okay, what documents do you have, and they come up with the answer, sorry, we don't have any documents because we were overstayed, we did not even make utility bill. To make utility bill, you don't have to be legal in the country. You can get various kind of utility bills, you can get various kind of IDs. So please don't sit at home, go and speak to your legal representative or send us information, and we will be able to respond accordingly. Quite a few people are watching from abroad as well. Welcome to you all. And quite a few familiar names as well. Thank you very much. And you have been giving me feedback on via email as well. And there are questions on email as well. And there are quite a few questions which are very common questions and people keep asking them. And there are a few questions again in relation to Regulation 9, Najib, of European regulations. As you know, you have dealt with so many cases where Regulation 9 is the area where you have a British sponsor, and British sponsor has come back to UK. I believe, explained this in last session or in my YouTube video, that there is another change, yet another change. And that change is, when your British sponsor comes back to UK, he does not have to prove that he's working here. As long as, this is very recent, 2-3 weeks ago change, so as long as he worked in that European state for at least minimum 3 months, that employment was genuine, main employment, and the dependent applicant was staying in that state, EA state, as a dependent with him, and you have proper documentation for that, then you should be making an application. That center of life strict criteria and coming back and having treaty rights here, that is all abolished. It's too late though, because we have only few months left, but even those cases where the Home Office had refused, even FTT had previously refused the appeals, the upper tribunal has granted permission on those basis that center of life is not the test anymore, and British sponsor who has come back to UK and he must be working, that is not the test anymore. So it has become very flexible, the way it should be and the way it was in 2014. Earlier when Surinder Singh Root was there and people were doing these cases until 2014-15, but then appeal rights were taken away because of this case of Salah. Then the new regulation came 2016, which was implemented on 1st of Feb 2017. So they said Regulation 9, it took away all the relations apart from spouses. So that was challenged. We challenged so many cases, and Nahisa, one of those lawyers who successfully challenged those, and we claimed the costs as well. And recently a very difficult case it was at that time, but Mr. Naji has managed to get direct indefinite leave to remain from the Home Office, not 5 years visa, direct indefinite leave to remain from the Home Office, because this person had been staying with his sponsor in Ireland and UK for over 5 years. And on those basis, I did say that this is not regulation I'm talking about, this is my own experience, and I shared this with you guys, that all even extended family members here who have spent 5 years with their sponsors in the country, even though their visa was granted afterwards, should try to get settlement visa, not pre-settled. So if they refuse, you can challenge that, and very likely they will refuse, but you should challenge that. But we have cases where they have given settlement visas before they spent 5 years after the visa grant. So as long as altogether you have spent as dependent on your spouse, they will try to bring this technicality in there, but that should be challenged.
Yeah.
If you want to add definitely on Regulation 9, I believe.
Yes. Today, without mentioning any client's name, we have received an email, although we are receiving a lot of emails, but this email, I just wanted to point out, because the Home Office has set up a plan whereby they are now actively reviewing all those cases which they had initially refused under Regulation 9.
Right.
So they have today sent us an email saying, look, we are asking, because the case is in the court, so they have copied email to us and seek our observations on that. In that, they have made an application to the court asking them that, look, we are ready, we are willing to withdraw our decision with the view to grant.
With the view to grant.
With the view
so
to
that
grant
is a floodgate, Najib. If
Yeah.
the cases we have, as you know, we have quite a few cases in the court where we have even been granted permission, and we are waiting for the appeal hearing dates, and because of this pandemic situation, we are not getting those dates. So what are you saying? What you are saying is that Home Office is willing to withdraw those decisions with the view to grant. That will save a lot of hassles for the clients.
Only condition they have put in place there, which I think is not a bad condition, is that subject to status checks.
Right.
I think that is reasonable for them to seek their verification.
When you say status check, that means the criminal side of it, or what?
I think probably they want to make their inquiries whether the sponsor was working or not.
Okay. Right,
so it's
right.
basic.
So they may ask you few more documents in relation to that, but if they are satisfied, then obviously these technical issues which were there under Regulation 9 especially, so since the courts have been brave but very late, whatever decisions are coming now, if these decisions would have come 1 or 2 years ago, it would have helped so many clients who have been suffering, because they would have got the permission to work and they would have been contributing towards the UK economy.
Indeed.
And they have been burdened until now. So this is really a great news, and this is a news for every one of you who have been in this situation. So please contact your legal representatives, and if need be, submit representation to the Home Office on these basis. They may have received the same email. Even if they don't, if they haven't, please contact them and pursue this with them. That is really great information, Aisa.
Yes.
Yeah. Any other immigration news you have in your mind at the moment? Please share with us.
There are not many, but in cases we have been quite successful in winning almost all
Regulation
those
9 especially.
Regulation 9 cases They had been pending for a number of years, but we worked hard on those and we were able to clarify the case law on that, and finally
Yeah, and
we got them.
few of our
Yeah.
clients which are still there and their cases have not been granted yet, they are sticking with me. Thank you very much, as I've been very much hopeful from day one that we will get these cases through, and we are coming to that stage now, and we are getting those cases through. So if you have any issues in Regulation 9 or even Regulation 8, anything to do with European regulation, which is not going to be there after 31st of December, so please act upon now and contact your legal representative or send us information, and we will respond to that. There's a question that that in my application, do I need to mention my speeding offense? However, I took the speed awareness option. Yes, if you were caught speeding and you were taken to the court, or if there is a conviction. You see the question in the forms normally are, have you ever been convicted? So if you were convicted, then you have to mention. So even like in civil matters, if there is a CCJ, or even if there was a caution in criminal, so you have to mention that because there are specific questions. But if there is no question and police did not take it further, then obviously you don't have to mention, because you have to be very particular. The application form is very, very clear. You don't have to give unnecessarily extra information which is not in your favor, but if they ask, you cannot hide that information. So, and similarly, there are instances where you have made an application is gone, and after submitting the application, you have got 2-3 points. So people say, okay, what should we do because we didn't mention in the application? Yes, that's fine, because at the time of application you did not have this conviction, you did not have those points, so you didn't mention. It is fine. Yes, when you come, and even if you do mention, you see, now you can tell the Home Office, and if your application is for extension or for indefinite leave, these kind of traffic offenses are not, unless it is a dangerous driving and all that, these kind of offenses are not going to damage your application. However, if this application is for nationality, then yes, they are more strict on that, so you need to seek advice before you make nationality application. But in terms of any leave extension, it's okay, you can mention if there is a conviction. If there isn't, then you don't have to mention. So thank you very much for your questions via email as well. There is another a common question, Naji Saab, which is about the parents' route. As you know, the parents who are abroad and they have their children, all of their children settled here, they don't have any children back home. Financially, they are dependent on their children in the UK, and still they make the application and the application's being refused.
Unfortunately, under immigration rules, the rules are much strict. There is hardly any chance to get visas under that category. But all is not lost. There are still, we can still make human rights applications, and we have been successful in getting few of those. And yeah, I think that the only option available to them is to make a strong case, prepare their case fully, and rely on their Article 8 grounds, and submit their applications. And if they are refused, then I will advise them to appeal,
Yes.
or successfully judicially review the decisions. That's where a lot of people make mistakes. When they are refused, they think this is the end of the game. In fact, for us, the case starts from there. Once you are given refusal, you see no light, you think you have reached the end of the road, but for us, the journey has just started from there. So that's what we advise you guys. If any of you has been refused, where they have not been even granted an appeal right, we can successfully challenge that decision.
Thank you, Naisab. And I would add there, when you're making an application, try to make it compassionate. And on compassionate, the agreed and accepted compassionate ground is medical ground. So if they're elderly and they have medical problems, please do attach all those medical reports. And plus, I have realized that especially in Asian community, we do not consider depression as any illness, any disease. There are so many people at this age back home, they may be suffering from depression. They have the symptoms, but they don't know. So you need to elaborate that. And if that is the case, you need to have psychiatrist reports with them. And if those people are saying that, look, because they are living on their own, they may have lived 100 years if they were living with their children, but because they're living on their own and they are depressed, their life expectancy may decrease. This is the magic wording. Their life expectancy may decrease if they live on their own. So these kind of reports, documents, if they relate to their genuine situation, please attach those, because even if they refuse, these documents will win you at the appeal. You see here, when we sit in front of the judges, we have compassionate grounds, we have documents, we have direct evidence from the sponsors, the children. It does make a difference. When you're making applications to entry clearance officers or to Home Office, the best you can do is in writing and send your documents. But when you are sitting at appeal, your lawyer, your advocate, yourself, you can explain, your emotions can be counted. So under Article 8, there's a lot you can do, but you have to have proper advice before you make the application, not after getting the refusal. Naisab, there's a question here that a person is asking, welcome Avirsab, that my wife, I'm British and my wife and 3 children are here on partner route or spouse visa. Now the children have become over 18 and they are going for ILR application. Do they have to do English test and life in the UK? Everybody who has become over 18,
Yes.
even though they are dependent visa with mother or father, they still have to do both tests when you're making application for ILR. Yes, they still are over 18, but they're still dependent, so they can be part of the application. There's one technical question, Aisha, where the case is a lady has come on spouse visa in this country with 3 children, similar situation, and 3 children have become over 18. They're supposed to do the English test. They have done those tests. The mother herself could not do the test. Okay, the main applicant being the mother, you're sending the application for ILR, the mother without the English test, the children with English test, fulfilling all the requirements. So where do we stand? Would the Home Office give an extension and other category visa, not under spouse category, for the mother, so she can carry on and do the test, and whenever she does the test, she can come back? But the children got all the requirements met, the income threshold is there, will they get indefinite?
If I was the caseworker on that application, I would approve their applications in a way which serves the purpose. For instance, if I was the caseworker, I would not refuse the mother, but instead give her further leave to remain. But the children, because they meet all the requirements of the rules, they should be able to get indefinite leave to remain.
So Jogaji, you got your answer. You have been asking me this question, and I confirm that yes, you should be making the application. Mother will get extension in worst case scenario under the same category until she does the test. She will not get indefinite without the test. That is for sure, unless she had exemption certificate, some medical reasons. But the children have fulfilled the requirement, so they should be getting indefinite leave to remain. So please go ahead and make the application on those basis. So that is quite interesting, because a lot of people, they get scared that what if, since my wife was the main applicant and these were dependents, what would happen? Will we lose our, the Home Office fees? It's extraordinary fees at the moment.
With the Home Office, you never know, but we can only advise what we can think is appropriate and proper.
Okay, so welcome everybody else who are still joining us. There are quite a few people from abroad. Welcome to our session. So if you have any questions, please do send us, and we will try to respond to you. Whether it is immigration matter or it's a non-immigration matter, we are not just an immigration firm. We do all sort of cases. We have quite a big practice on property law. We have civil litigation. We also do limited criminal cases as well. So whatever you have in your mind, please come up with your question, and we will try to resolve. We also can give you limited advice on finances. If you are looking for short-term loan, we have associated financial advisors, so we can help you on that as well.
Prince Mohsen has asked for our email address, which is info@m-rsolicitors.co.uk.
Yes, that's info@m-rsolicitors.co.uk. There's a question that someone with Home Office gave NI and 6-month permits to work, and up till now his stay not been given, 6 months has expired. I didn't quite understand the question that what kind of visa is this where you have been given only 6 months visa. The only 6 months visa I can recall, Naisab, is under European routes. When people are coming from abroad, they get 6 months visa, they get NI number and everything, and then they apply for the proper 5 years visa here. So if that is the case, or whatever case, first initially you were given 6 months leave under whatever category, and you were given NI number and you were working, and within time you have made a new application and it is still pending in the Home Office, you are allowed to work. Your status is legal, if this is your question. But if you are trying to ask something else, then please do ask us clearly again, or as we said, you can send us an email.
I think they might be referring to the certificate of application, which normally people misunderstand that it is valid for 6 months.
The European route.
Yeah, under
yes.
the European route. It might be the case that she's referring to that. But if that is the case, although it says that it is for 6 months, people's understanding is that it is for 6 months, but it clearly states there that unless and until your application is decided and then your final appeal is lapsed, until that time, if it runs for 6 months, a year, 2 years, even in some instances it has run for 2, 3, 5 years even, that work permission letter remains valid.
And on top of that, if you are in any doubt, we have cases where we have requested the Home Office to issue a new one.
Yes.
If your case is pending, even if your appeal is validly pending, you can still ask the Home Office to issue you new certificate, so they will issue new certificate. There are a few questions about our fees in particular cases. We cannot give you fee range here because it depends on your particular case. Fee can be 750, fee can be £5,000. So that depends really on your particular case. So if you need to know our fee in a particular case, you need to send us an email with some background. We will ask you a few questions, and after that we will be able to quote you the exact fee we would charge in that particular case.
Yeah, she has clarified so if that is the certificate of application, as I said before, it remains valid as long as your application is not decided or if your appeal is pending. But if you need, sometimes in circumstances, employers request a new one, you can always request Home Office for a new certificate of application, and they can give you quite quickly, and that is free of charge.
Right, Vlad, your question again, which is more elaborated now, that your friend was given 6 months visa and the gap was less than 14 days, and they have given 6 months visa on discretionary basis. Now time is up and you can go for tenure or not. Yes, you can go for tenure. You see, the best practice is, if you are in doubt, you can, and this is for everybody, you can always request your file of papers from the Home Office, DPU record. You can always get under Data Protection Act file from the Home Office, that file, and it is free of charge. Yes, solicitors do charge, we do charge for to get the file for you, but there used to be £10 charge, but there is no Home Office fee anymore, so you can do it yourself. So once you get that file of papers, which may take 6 to 8 weeks, or hopefully earlier, because they have started doing it online now. So once you receive that, you will know the history. What is in your mind and what you know may differ from the record Home Office has, rightly or wrongly. So if there is more gap, you know that there is something wrong in it, you clarify that rather than making an application, getting it refused and going to the lengthy and expensive appeal process. So it's always better to have information in hand before you make the application. But if you're damn sure that there is no gap, 10 years continuous without any gap, yes, you can make application for ILR. There's another question. Anusha, welcome and congratulations
and
as well.
Congratulations as well, yes.
Okay, from both of us. And now the query is, yes, it was not that long battle, but you have been lucky. Illegally, she has completed 15 years here. She is ex-army person from Sri Lanka and she got a gold medal for sniper shooting. Wow, okay.
Be careful.
In Asian Games as well. So she is a well-renowned kind of person. She has some skills. She has some evidence to prove that. So these situations, she should be making an application. Also, if she thinks that there is a department where she should have been given an opportunity, she should communicate with them. She should try to get some reference. And if they say, yes, your skills, your experience, your education, your award, if you have status, we would have given you the employment. So that reference letter is very strong evidence that she is needed in the country for UK economy. Or if she can bring up a business plan which shows that she can set up something which will benefit the UK economy, and plus 15 years behind her, it is going to be a very good case. We are a little over time, but if we have left any questions, we will respond to you later on. We have received quite a few emails we can see, but we will respond to that as well later on. You will definitely get the response. Any other question arises from our session or you have in your mind, our email address, we have repeated, info@m-rsolicitors.co.uk. Our office landline number is 0208 518 1956. Is that correct, Naisa?
Yes.
Okay, so that is the correct number. So please either send us email or contact our office if you need to make an appointment. We are still working remotely mostly, but within next few days we will be seeing necessity appointments face to face with this social distancing in place. But we are open to Skype and telephone appointments. If you have any queries, please contact us. So Naisab, it was very useful session today, and I'm sure people on immigration and property matters got this valuable information, and this especially the latest information on Regulation 9 under EU regulations, what Naisab has given you. Please, 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 this is very important one. Do contact your solicitors, your legal advisors, or contact us and pursue your cases with Home Office. So until next session, bye from us. Look after yourself. Stay alert. Thank you. Bye-bye.